Now, let's go back to court. From cleaning the scene, officers lacking the necessary qualifications to conduct oversight at the murder trial, and officers keeping evidence in their personal safe. Today's testimony at the Meyiwa Murder Trial covered a variety of different claims. Forensic officer Meyiwa Murder was back in the hot seat today, detailing his version of events and his qualifications. ENCA reporter Stindra Masigane is following these developments. Let's cross live to Sli. I just want to know, first of all, what happened behind closed doors after that short adjournment pertaining to a complaint against the media?
Well, we had a discussion with the registrar, the judge's registrar, just to clarify exactly what the rules should be around adjournments and audio that needs to be cut, as well as visuals during these adjournments. Of course, that complaint being raised by Advocate Mshololo. For those who don't understand how we're providing the broadcast from court, is that we're all, in terms of the TV broadcasters, we are being fed via the SABC that's providing pool feed, and so their technical teams essentially just need to be briefed ahead of court proceedings that during adjournments they need to cut the visuals as well as audio so that counsel may be able to consult with their clients. But back to what happened in court, of course, once more Sergeant Mosia under scrutiny in terms of how evidence was collected, how evidence was stored. Already Advocate Mshololo poking many holes in terms of how that evidence was collected, even suggesting to the courts that evidence was planted and that the scene was contaminated much before police could arrive at the scene. For more analysis, I'm joined by legal expert Marius Tutoy. Thank you so much for your time this afternoon. Just give us a sense as to, does the state have a problem here? Because many issues coming up around how evidence was collected, suggestions that there was contamination, even planting of evidence.
Yeah, that could have a material bearing on the state. Remember, the state bears the onus to prove the guilt of the accused beyond a reasonable doubt. And if they, of course, have a tampered crime scene, and we know that there were casings found on the crime scene, we know that the projectile was found on the crime scene, we know that blood and DNA was collected, the moment you have a tampered crime scene, it becomes very difficult for the court to draw inferences from where exactly what was found if the crime scene had been tampered with. Because if the argument is that I planted, for argument's sake, the casings on the crime scene, and that we know the crime scene has been tampered with, how easy is it to get away with that? So the whole idea is you would want a pristine crime scene. You would want a crime scene that's immediately cordoned off, that nobody is allowed to enter it, that you have people in forensic gear that enters it so that they can't contaminate the scene. You would want to do a number of things to secure your crime scene so that when you collect forensic evidence, that you can, at the end of the day, when you testify in court 4 years later, say to the court that I can conclusively say that this is accused number 1, 2, 3 or 4's DNA because I found it here. But the moment the crime scene is tampered with, it makes it very, very difficult to draw those inferences.
Issues around the qualifications of Sergeant Mosia. He seems to have only qualified and gotten his degree in terms of forensics a year before actually attending to the scene. Is this going to have a bearing?
Well, first and foremost, you would want a matter that has such a high profile than Senzo Meyiwa's killing to have the necessary attention from the highest ranking officials in the police. So if you have a sergeant attending the crime scene who's barely qualified, who's still studying, it does not bode well for your forensics in the trial. It doesn't bode well for the way the crime scene was preserved or the way you actually dealt with the crime scene. So it really smacks in the face of the complainants, the family members who lost a person, and say, well, listen, the cops simply just did not do their work.
Lastly, we know that an ID parade was not conducted. Will this have an effect in terms of finding guilt or innocence for the accused?
It all depends on what evidence the state is relying. If they're relying on forensic evidence, DNA, blood and that sort of thing, fingerprints, then you don't need an eyewitness. Then you don't need somebody to say, identified this person. But we know that Kelly Khumalo was in the crime scene. We know that other individuals were there. So if they did not attend an ID parade, it means that either they stated in their statements, I cannot identify the suspects, number one. Even if I see them again, I won't be able to identify them. Or it just means that due to the lapse of time, the cops believe that it was a waste of time to hold the ID parade. And of course it will have a bearing on the trial, because if that's the only evidence you rely on, you've got a big problem. If you have other evidence, well, then you can still overcome that.
Do you think the state not calling those who were in the house and present when Meyiwa was shot could collapse their case?
Well, you would expect the witnesses who were at the crime scene to be called to testify. If they don't call those witnesses, remember at the end of the day, the state once again bears the onus to prove the guilt of the accused beyond a reasonable doubt. If they don't call essential witnesses, the court can draw adverse inferences from their failure to call those witnesses. And adverse inferences in this instance is, you didn't call this witness, you should have called this witness, so I'm now saying, I'm drawing a negative inference and saying you should have done so, and this prejudices your case and it prejudices the ruling that I'm going to give.
Lastly, confessions. Apparently there are confessions. How admissible are they?
Okay, first and foremost, when you talk about a confession, you're talking about a freely and voluntarily admission of guilt amounting to a plea of guilty. So it must cover all the elements, and the person must be in his sound and sober senses. So he cannot be assaulted, cannot be tortured in the process of getting a confession. But that confession is only admissible against me if I'm the person making the confession. Then it can be used against me. If I go and I repeat as the suspect now, I go and testify in court and say, listen, I did make this affidavit, and yes, or I did make this confession, and yes, I did include accused 3, 4, and 5, then immediately the fact that I've repeated it now becomes admissible against them. But if I say, listen, I never made the statement, I was tortured, it's not my information, the cops included the information on the affidavit or on the confession, then it's only admissible against me, not against the co-accused that I might reference in my confession.
I think that's all we have time for. Thank you so much, Mr. Du Toit. I hope I have another opportunity to speak to you. That is Mr. Marius Du Toit, a legal expert, just giving us some analysis on what we've heard so far in terms of what's been unfolding inside court.